afternoon, everyone, and welcome to the Future of Europe, your weekly TV show on subjects of the European Union. Hello, Elise Hirsch. We invited you on the show because you wrote a paper that raised a rather interesting question. So, to what extent the interference with freedom of expression be justified in the context of statements that advocate terrorist acts? To answer this question, you wrote you were inspired by the Jean-Marc Rouillan case, handed down on the 23rd of June 2022 by the European Court of Human Rights.
Yeah, that's right. So it's really the reading of this case that made me think about Europe's place in the limits of freedom of expression, especially concerning hate speech or the apology for terrorism.
Perhaps before getting to the heart of the matter and giving your thoughts, could you quickly remind us what is this case about? Because we don't really know it, and for our viewers who may not have them in mind.
Yes, totally. So Jean-Marc Rouillan was 69. He has spent nearly 25 years in prison for terrorist killings. So he was released in 2012. He gave an interview in 2016 in which he commented the attacks committed by the terrorists on Paris and Saint-Denis in 2015. So he said, I quote, "I found them very brave. They fought bravely." So, of course, he was prosecuted for these remarks. He was sentenced to 18 months in prison, 8 of which were firm. And so the European Court of Human Rights condemned France on the 23rd of June 2022 for having imposed an excessive prison sentence on Jean-Marc Rouillan, who is, to remind our viewers, the co-founder of the far-left armed group Action Directe. So he was sentenced to 18 months in prison, 8 of which were suspended for apology for terrorism.
All right. And what did Jean-Marc Rouillan invoke before the European Court of Human Rights to challenge the national judgments?
So Jean-Marc Rouillan challenged the judgment of the Cour of Cassation, pointing out the lack of precision in the definition of apology for terrorism in French legislation, and thus a risk of arbitrariness on the part of the judge. He also points out that the context in which he made these remarks was not taken into account and that they were distorted in the national judgment. So on these grounds, Jean-Marc Rouillan invoked Article 10 of the European Convention on Human Rights to assert his freedom of expression.
And does the European Court agree with these arguments?
No, the court supports the interference with freedom of expression by explaining that complicity in the defense of terrorism justifies restricting this right, even though it is a fundamental right. The general interest framework of the debate was not sufficient to compensate, I want to say, for the positive image painted of the terrorist and the large audience reached by the radio format, because he said those words in the radio. The court saw no reason to depart so much from the national jurisdiction. However, the court reconsidered the sentence, as I said earlier, which was considered too long and disproportionate.
All right, well, very interesting. And so before precising the court's position on the longevity of the sentence, could you please review the existing legal framework in Europe concerning hate speech or praise for terrorism?
Yeah, so the court has, through its jurisprudence mostly, highlighted conditions that make it possible to define a sort of cursor of what falls within the legality of freedom of expression and what falls outside of it. So typically, the court asks the question of who says the controversial statement. So I can give you an example. For example, in Perinsek versus Switzerland, which was a case that was ruled in 2015, the applicant made statements denying the existence of the Armenian genocide. So, because he considered it an international lie.
Okay.
So the court considered that, as the applicant was a doctor of law and an informed political figure, and as the Swiss National Council had recognized the existence of the Armenian genocide in 2002, the criminal sanction was foreseeable. Because he was a doctor, he should know that sanctions was foreseeable for saying such things as the Armenian genocide was an international lie. So in its case law, the court also emphasizes the importance of the context in which the statements were made. So to come back to our case, in the Rouillan case, having taken these conditions into account, the court sided with the national judgment because of who said the remarks and what, in which context he said it. So I also want to stress on something that I find important. This condition for interference is shared by the Court of Justice of the European Union, since Article 11 of the European Union of Fundamental Rights corresponds to Article 10 of the European Convention on Human Rights, and the meaning and scope of these rights are the same as those guaranteed by the ECHR.
Well, when I read your report, you cited a lot of cases, and well, I asked myself, why did you only cite one? Why did you stop at the Rouillan against France case? Is there an aspect of the judgment that particularly interested you?
Yeah, so there are a lot of cases that concern freedom of expression at the European level. But I think that this case law in particular illustrates the importance of naming and defining concepts legally so that the risk of an overly broad interpretation by the judge does not become an argument for making freedom of expression an absolute freedom.
And interference with freedom of expression is still pretty strong to act in a democracy. Are there other tools the court can use beyond the legal framework?
Yes, completely. The interference must also be justified by a legitimate aim, which was also confirmed here. So it was the legal aspect was confirmed, but also the legitimate aim. So it was probably inspired by the case of Leander versus Sweden, which states that the legitimate aim is very broad when it concerns the pressing social need and the national security.
I would like to return to the sentence. In this case, Mr. Rouillan received a sentence of 18 months in prison, 10 of which were suspended according to the national judgment. What did the European Court of Human Rights think of this?
If until now the court aligned with the French judgment, its position differs on the sanction imposed.
In what ways?
So noting that the applicant had been questioned by the journalist about the state of emergency introduced in France after the terrorist attack of November 2015, public freedoms and security, and considering that these issues were in this context likely to be of interest to the public, it concluded that the remarks had been made in the context of a debate of general interest. So it can be added that the majority of the legal literature, especially since Hanover versus Germany, is of the opinion that the public interest includes the reception of information and ideas of all kinds, even if they are not always confirmed or are provocative. However, even if they did not constitute direct incitement to violence, they conveyed a positive image of the perpetrators of terrorist attacks, and were likely through their broadcast and on the radio and on the internet to reach a wide audience. So in so doing, the court endorses the reasons adopted by the National Court, which enjoyed a wide margin of appreciation in concluding that the offense of apology had been committed. But the proportionality of the interference is also measured by the nature and severity of the penalties imposed, which must not deter the legitimate exercise of the freedom. The court recalls that the imposition of a criminal conviction is one of the most serious forms of interference with the right to freedom of expression, and that a prison sentence imposed in the context of a political or public interest debate is compatible with freedom of expression only in exceptional circumstances, such as the dissemination of hate speech or incitement to violence. In those circumstances, in this case, and despite the care taken by the National Court to justify the principle of the penalty imposed, its nature and even its aggravation, the court considers that the prison sentence imposed was not proportionate and not necessary in a democratic society.
So the court found the sentence disproportionate despite its length of only a few months?
It is interesting, actually, that the concept of proportionality was raised in Rouillan versus France, whereas it is only raised in very long sentences. Here it's only a few months. This case therefore represents an interesting and rather innovative jurisprudence on the requirement of proportionality of prison sentences that are not necessarily really long as we could imagine. And it's perhaps part of a more global trend toward less restrictive alternatives to imprisonment.
All right, well, thank you very much, Elise, for this analysis of the Rouillan against French case released in June 2022. Perhaps would you want to conclude with some specific words?
Yeah, maybe to sum up and that so that the viewers are really clear with all this case, we can say that the European Court of Human Rights has taken up the conditions for interference with freedom of expressions. So while it confirmed the prevention by law and the legitimacy of aim, it questioned the severity of the sentence and condemned the government. So acknowledging the apologetic nature of the applicant's statements, it can be considered that it is not so much freedom of expression that the court is protecting, but ultimately human dignity.
All right. Well, thank you very much for your intervention. And to all the viewers, see you soon on the next episode of The Future of Europe. Thank you very much.